in this session. We will be joined by distinguished panelists who we will introduce later on as we go along on the program. But just to let you know that we look forward to having a very exciting session and discussions on an important issue around reporting on Article 21 and 24 from the African Charter on Human and People's Rights, and the role that actors, both state and non-state actors, can play in terms of ensuring that the reporting is up to speed and actually captures the issues that we intend or we would want to see captured from that side. So I would kindly ask all of you to take your seats as we begin. I would kindly ask you all to assume your seats so that we can get started. So to set the scene, to give us the background as to why this session was conceived, I would first of all want to welcome one of my colleagues and friends, Wangari, to be able to give us a brief overview or background in terms of why we are here and what we seek to achieve within this session. Welcome all of you, and I look forward to having very engaging and interactive discussions with all of you. So Wangari, kindly take the stage and give us brief remarks in terms of why are we here this morning.
Thank you very much, Barisa. Distinguished delegates, ladies and gentlemen, good morning. I think it's still morning, or is it afternoon? Good morning. First, a huge thanks to the organizers, co-organizers of this session. I'll name them briefly. Zimbabwe Environmental Law Association, or ZELA, Lawyers for Human Rights, the Pan-African Lawyers Union, or PALU, the Center for Applied Legal Studies, and of course, my colleagues at ActionAid. I am Wangari Kinoti, and I'm the global lead for women's rights at ActionAid International, as well as a feminist activist for social justice. So naturally, this session today bears great significance for me, as well as I'm sure for many of us in this room. This is a capacity building session for all of us, myself included, looking at reporting on Articles 21 and 24 of the African Charter on Human and People's Rights, or ACHPR, relating to extractive industries, human rights, and the environment. We know that there are human rights and environmental impacts from extractive industries. We wouldn't be sitting here today if we didn't know and acknowledge that. What many of us may not know as much about is how to use this critical regional human rights instrument, the Continental Human Rights Charter. And I will always add, when we talk about the Charter, it's Protocol on the Rights of Women in Africa, commonly known as the Maputo Protocol. I'll come back to Maputo very shortly. But we may not know in detail how to use this critical regional instrument when talking about human rights and environmental impact. So this is a capacity building session to allow ourselves to learn more about that. So today you will be hearing from a panel of experts, including, at least I think that was the intention, the commissioner, one of the commissioners from the African Commission on Human and People's Rights. But anyway, a diverse panel of experts that will take us through Articles 21 and 24 of the Charter, giving us a comprehensive overview of the articles and building our knowledge on how they can be used for reporting on human rights and environmental impacts of extractive industries. And it is our collective hope that this knowledge will translate to concrete actions from all of us when we go back to our communities, our constituencies, our sectors. So we want this to translate into concrete action. It's important, and I hope our panel will address itself to this, to remember that these human rights and environmental impacts are gendered. Gendered structural violence is often institutionalized, intensified, and weaponized. We may have heard of the case of Chiadzwa in Marange years ago now, but Marange in Zimbabwe, where diamonds were discovered and then sexual assault and rape were used as a means to discourage illegal mining. In mining communities, as in most communities across the world, gender discrimination is rampant and normalized. Extractivism, mining, tends to place profit over people and the planet. We know this, and these are the things we're trying to address through forums like this, right? So our approach really ought to look at a problem or a situation and indeed solutions through the lens that accounts for, or lenses that account for those who are relegated most to the margins, whether this is due to their race, their age, indigeneity, class, ethnicity, migrant status, and other factors, including, of course, sex and gender. Extractivism often takes patriarchal power structures and uses them to its advantage. We have seen this right from the colonial roots of extractivism, particularly on this continent. So women and girls in mining communities who are already subject to gender discrimination bear the rights and environmental impacts the hardest. From the extremes of weaponized sexual violence, from like that example I gave, to additional caretaking and other labor roles following changes in the makeup of their households due to local mining activities, such as men going to work in the mines, we know about this, farming on less fertile land, constraints to movement by government or private security, impacts on respiratory and reproductive health, both for themselves and their children or households or other family members they take care of, and then sexual exploitation and many other areas which my remarks will not cover. There is decades worth of information on this, including that has been gathered and documented by women human rights defenders in mining communities, many of whom continue to be harassed at best, killed at worst. Therefore, our reporting on human rights and environmental impacts must also be gendered in content and approach. The Maputo Protocol, which I'm happy to say I campaigned for in the AU corridors those many years ago, it is now 20 years old, by the way, adopted in 2003. It is a progressive instrument on the rights of women in Africa, adopted as a protocol to the charter that we are discussing today. And I'm bringing this up because the protocol on the rights of women was necessary because, among other things, it was recognized that despite the ratification of the African Charter, various discriminations against women and girls continued. And therefore, a specific protocol on their rights needed to be elaborated. And that protocol has progressive articles regarding right to a healthy environment, sustainable development, and protection from adverse effects of globalization, trade, and economic policy. So the things that really we're going to be discussing today. Before Barisa reminds me that I'm not on the panel, my role today was to thank you for joining this important session. And to remind us all that this is for building collective knowledge, as I said at the beginning, and our other capacities that we then take home with us. And also to remind us that this is ultimately about building accountability. So not just reporting, but what happens after that? Who are the various actors we seek accountability from, and whose voices do we amplify, center, and lift up while we're doing so? So thanks very much again for joining this really important session. Asante sana.
Well, thank you very much, Wangari, for setting the scene for all of us. Indeed, we've come a long way. And for these instruments to be meaningful and to be impactful as desired, there's need actually to ensure that the reporting from the nation, from the states is at par. That's a process that normally brings together quite a number of actors. The states normally prepare their reports, sometimes in consultation with critical institutions such as the national human rights institutions. But also there's the other side where we have civil society who could also prepare their own alternative reports and submit to the commission. And those reports normally are viewed in parallel. So it's really important. If the reporting is not at par, it means then the critical issues that are happening at national level may not be effectively captured and reported on at the Commission's level. And that is why we are here to review this process. I know, Wangari, you touched on the articles from the Charter itself, Article 21 and Article 24. That is basically where we derive these reporting obligations as articulated in the Charter. So at this juncture, I would want now to bring to you one of the critical panelists who will lay the foundation in terms of how the Charter itself is structured and what are the obligations that are placed on the states and what is contained in those articles, so that then all of us have a clearer understanding of what is expected from the side of the states and how each one of us can be able to support that process, be it from the side of civil society or national human rights institutions who are also present in this room. So at this juncture, allow me to call on our next presenter who will give us a keynote address from the African Commission on Human and People's Rights. And that's Commissioner Mwandenga. I don't know, he was supposed to be online. I don't know whether you can hear us, and if you are present, kindly, the floor is yours. Kindly join us and address the floor. Do we have Commissioner Mwandenga online? Just checking. If not, I think we will skip and give them the floor when they appear online afterwards. But their role was basically to set the scene in terms of the contents of those two articles that I mentioned or I alluded to, and then the progress in terms of their implementation and the role that the Commission plays in supporting this process, the reporting process around these two articles as contained in the African Charter. But since they are not ready online, I think we will skip that for now and proceed straight on to the panelists who we have. So colleagues, we have people who have been interacting with this process. There are institutions like the Kenya National Human Rights, Kenya National Commission on Human Rights, who have been on the ground, and they have reported on these articles progressively for a number of years. So we would want to hear from them. What have been their practical experience around reporting on these articles? What are some of the challenges they have experienced in the process? And how can the rest of us be able to pick lessons from that and probably improve and make this process more inclusive and impactful going forward? So we'll hand the floor to Madam Christine from the Kenya National Commission on Human Rights to give us an overview of your experience so far in terms of reporting on these two articles as contained in the African Charter on Human and People's Rights. You have the floor.
Thank you so much, Mr. Barisa. I speak on behalf of the Kenya National Commission on Human Rights, which is a national human rights institution in Kenya. We are established under the Constitution and our enabling statute, which is the KNCHR Act. We have two broad mandates, a promotion mandate and a protection mandate. And under the protection mandate, we do monitor, investigate, and report on the status of human rights and human rights violations in the country. We are an accredited A-status national human rights institution, meaning we are fully compliant with the Paris principles. And as a result of this, we have affiliate status before international and regional human rights reporting mechanisms. And it is from this that we have audience before the African Commission on Human and People's Rights. So just to speak briefly on how we undertake monitoring with regards to Articles 21 and 24 of the African Charter, We draw most of our information from the work that we do as a national human rights institution. So we do conduct audits, we do conduct assessments, where we do engage with businesses, civil society actors, with the state, with the ministries, departments, and agencies of the state, just to gather information on some of the human rights issues that are rising in the extractive sector. We also do research and advisories, which we then issue to the relevant stakeholders, mostly ministries again and departments, agencies of the government, especially when we're reviewing laws and policies. And we've done this in collaboration with other state agencies like the National Environmental and Management Authority, the Ministry of Environment, and the Ministry of Mining. So we try to look for collaborative ways of gathering views and impacting legislation and policies. We also do complaints processing. As an NHRI, we can either receive complaints from members of the public, or we can process complaints of our own motion. And we have done so in the extractive sector. Once we receive a complaint, of course, if it meets our criteria, then we proceed to do investigations just to establish or to verify the human rights violations that have been alluded to. Over time, we also take note of systemic violations, and this results in us conducting public inquiries in the country. And we've done 2 such inquiries within the extractive sector. During the public inquiries, we invite stakeholders and members of the public to come and share their views, to share the challenges they have, and to also share some of the recommendations that they would prefer to see or adopted by the state. The 2 inquiries that we've done have been on salt mining and also just mining extractives as a whole in the coastal region in Kenya. And as a result of this, once we get the findings, what we come up is with recommendations, and these recommendations we then share with the stakeholders who've been adversely mentioned during the inquiry process. But we also present the same reports to the National Assembly, to whom we directly report, as well as to the president, because then we want to see some of these recommendations being incorporated, even when we're doing our regional and international reporting to various treaty bodies and charter mechanisms. As part of monitoring also, when we were developing our national action plan on business and human rights as a country, the extractives sector really came up with a lot of challenges or violations being mentioned. And if you go through Kenya's NAP, it's skewed, or it focuses a lot on land issues and extractives, because at the time at which we were developing it, the extractives industry was really big or being adversely mentioned on violations. When it comes to reporting, we do report at the national level. Like I've mentioned, we report to Parliament and we report to the President. We share the status of human rights in the country with them, but we also do report to the African Commission. The state, through the Office of the Attorney General and the Department of Justice, prepares the state's report, which they submit to the African Commission. But as an NHRI that has audience before the African Commission, we then develop a shadow report, giving our position as an independent mechanism, or as an independent body monitoring the status of human rights in the country. So we prepare a shadow report or an alternative report. And how we go about doing this is we engage with stakeholders, because we do appreciate that the civil society organizations have wealth of knowledge, or they know the status on the ground. So as we come up or as we develop our report, we then engage. We have a process of engagement just to share some of our findings and to also borrow lessons and findings from the civil society organizations. It's also influenced a lot with the work we do with the members of the public. So our complaint system gives a lot of data that we use in our reporting or in generating the reports that we do submit. Upon submission, every so often, we are invited to present during the sessions of the African Commission. We do not have voting rights, obviously, but we are given audience and we're allowed to speak up on the issues. Tied to that, we also do international reporting through the universal periodic reports that we prepare. During the review, we prepare alternate reports to that the state presents. And in this, we identify the lessons, the challenges, and recommendations that we would like the state to take up. But, then we use the Human Rights Council to urge the state to take up some of these recommendations. Briefly speaking on the challenges that we have experienced when it comes to reporting under these two articles or reporting to the Commission is the non-recognition of our data as an official data source for the state. Given that we do a lot of work on collecting the issues in the country, we present it in our alternate or in our shadow reports, but for the longest time, the state itself could not rely on the data that we generate. But that's something that we are now working towards, so that as the Kenya National Bureau of Statistics is gathering information that is then relied on by the state, it adopts a human rights-based approach. And so we are working on indicators and on a mechanism to have our data made official. And then, of course, is low uptake of the recommendations by the National Human Rights Institution. And this is a big problem for us when it comes to, infusing human rights-based approaches in how the government comes up with some of the laws and policies. Then, of course, is lack of enforcement of the recommendations by the African Commission. We've had 2 cases touching on the indigenous communities in Kenya, where the African Commission and the African Court have actually given judgments, but we are seeing a delay or some setbacks when it comes to implementing the recommendations and the judgment by the state. Then, of course, there's also delays in reporting, where the state is required to report to the African Commission, but it's a periodic report. But every so often, by the time we want to also give our reports, then we have some setbacks because the state itself has not presented the main report. Then, of course, issues of ineffective public participation. In the extractive sector, public participation is paramount. It's information that you need to get from the ground because it impacts communities, it touches on land, and many other facets that are very crucial to the country. Then one of the bigger challenges that we also have as an NHRI that reports under these 2 articles is resource constraints. We are a constitutional body, and so most of our funding comes from the state. So you can imagine the catch-22, because we are funded by the state, but we're also reporting on the violations most times by the state. When it comes to good practices that we have, we've adopted as an NHRI, we really believe in stakeholder engagement when it comes to preparing these reports. And we must also laud the state because as they prepare the main report, they do engage a good number of stakeholders just to get input before they submit the report. And as we prepare the alternative report, this has also come in handy because we believe in citizen-generated data as well, because of course we cannot capture all the issues on the ground at all times. So at this point, the civil society organizations have really been helpful, as well as human rights defenders. The other practice that we have is we provide technical support to civil society organizations. We urge them to also report to the African Commission on some of these areas, because we have civil society organizations that focus mainly on extractives. And so the amount of information that they have cannot be captured perhaps by ourselves or by the state. And so we give them just support on how they can go about preparing their alternative reports. We also do work on the recommendations given on the state. We try to work with government to implement some of the recommendations that we get back from the sessions at the African Commission. And last but not least, one of the better ways that we hope to move forward when we're implementing the guidelines on reporting on Article 21 and 24 is the same approach that we took when we were developing the National Action Plan on Business and Human Rights, because how we came about developing it, it was a recommendation that was given to the state. And so in the same regard, we hope that some of these recommendations given by the African Commission, the state can take up and, form a multi-stakeholder committee that can now proceed or progress with implementation of the recommendation. In a nutshell, I would say that's how we go about reporting on Articles 21 and 24. Thank you.
Yeah, a round of applause for her. Awesome. That's really great. Quite useful insights there. And you also raised quite a number of issues in terms of the challenges that you experience, even as you engage with this reporting process. You alluded to the fact that the data that you generate as an institution sometimes is not recognized by the state, and therefore it cannot be included as part of the official data for reporting. We could interrogate that a little more, because I know there are other institutions who have sort of gotten into some memorandum of understanding with the national statistical offices, so that the data that comes from the national human rights institutions can be officially recognized. So I know that's something that we have pursued elsewhere, and it could also be one of the things that we pursue here in the country. You also spoke about the low uptake of the recommendations that come from the Commission. Yeah, sometimes the institution gives very good recommendations, but because of the challenges that are also experienced at the African Commission level, at the institutional level, some of those recommendations end up not being implemented as fast as we would desire them to be implemented. And those delayed recommendations also amount to some kind of delayed justice, because the desire is for us to ensure when recommendations are given, they are acted upon almost immediately, so that then benefits can accrue to the affected communities. So that is an area that we could continuously engage on and deliberate with all the actors that are responsible, so that then justice can be dispensed at the earliest time possible. You also talked about issues of delayed reporting, especially from the state, which is a big problem. The report is periodic, as you mentioned, but when the time for reporting, especially from the state, comes, they're probably not ready to report, or probably they decide to delay that process, perhaps because they feel they're not ready, or there are issues that they do not want to address themselves to at that particular time. And that has an implication, because the reporting from the NHRI is also dependent on the report that the state itself has presented. In as much as the NHRIs have standing before the Commission, but I think their reporting is also based on the report that the state itself has presented. So if the state report is delayed, it has a lot of other implications, including what we've just discussed, among many other things that you raised, of course. In the interest of time, I think we have heard from the side of the National Human Rights Institution as a critical player in the reporting process. But ladies and gentlemen, we also have the privilege of having a representative from the Attorney General's office in Ghana, who should be able, now to give us the perspectives from the state. How has it been from the side of the state in terms of interacting with these two important articles, and how has the reporting process been? What are some of the challenges from the side of the state? We've heard from the side of a quasi kind of judicial organ, the National Human Rights Institution. But how has the experience been from the side of the state? So we are privileged to have a representative from the Attorney General's office in Ghana to give us their own interaction or experience in terms of interacting with the process and their own experiences in that regard. So Dr. Sylvia Adusu, Chief State Attorney, International Division Office of the Attorney General and Ministry of Justice from the Republic of Ghana. You have the floor, madam, for the next few minutes to engage and interact with the audience. You have the floor if you can hear me. Are you online? Dr. Sylvia, if you can hear me, are you online? She is. Can you hear me? If you're online and you can hear me, we would like to hand over the floor to you for the next few minutes.
Okay.
Awesome. Most welcome. You have the floor.
Thank you. Okay. Thank you very much. I'm honored to be online this morning in Ghana. Good morning, all of you. And I'm happy to be with you to discuss this important topic that we have. I have heard the presentation of the NHRI from Kenya, and I think we all have very similar issues in Ghana as well. But today my presentation is from the side of the state. And in this presentation, I will look at the challenges that Ghana faces in reporting its obligations under Articles 21 and 24 of the African Charter. I'll look at the little progress we have made, not much, and then our capacity needs and gaps, and then the areas of collaboration with other stakeholders. Now, these two articles, Article 21 and 24, specifically deal with the extractive industry. Article 21 guarantees the rights of all peoples to freely dispose of their wealth and natural resources. And Article 24 provides for the right of all people to a general satisfactory environment favorable to their development. And in this context, environment is used in Article 24 of the African Charter, referring to natural surroundings, including the soil, the flora, the fauna, the air and water bodies, as well as the living species in such water bodies on which people depend every day for their daily lives and survival. And these rights of peoples are at the very core of the concerns that surround the protection of rights relating to the operations of the extractive industries in Africa and in Ghana. Now, before we get to the challenges, I'd like to give you a little background to the issues that Ghana currently faces regarding the extractive sector, not different from other countries in the sub-region, I must say. Now, Ghana is very rich in natural resources. We have aluminum, we have bauxite, we have gold, manganese, oil, and gas. However, we are best known for the abundant gold that we have in this part of the world. In fact, that is why Ghana was called the Gold Coast. Now, at the moment, gold is actually the one that the focus is on in terms of the extractives. It's the first gold mining companies. We've been mining gold for very many years. In fact, since 1874, when the British set up the Gold Coast, there were two gold rushes in the early 1900s, and then gold prospecting and extractives were widespread in places like Obuasi, Takwa, Prestia. These are the mining areas of Ghana. And currently, we do have a little, not a little, we do have an issue with gold mining in Ghana. People are agitating. And but the fact of the matter is, looking at our reporting of Article 21 and 24, we can see that we have not been reporting generally to the African Commission. We have not been reporting under Article 62 as we should. Our initial report was in I think 1990 to 1992. That was when we did our initial report. And it was a summary of 10 laws on the protection and promotion of human rights and children, women, labor, education, and the judicial service. Our second report was from 1993 to 2001. It also highlighted the 1992 Constitution. And but we didn't say anything about Article 21 and 24 of the Charter. So that has actually been the scenario. And right now, we are trying to put together our national report to take care of all the backlog that we have. But we have a number of challenges. First of all, as with the Kenyan NHRI, we also have a lot of resource constraints, not only financial, but also in terms of people. We have limited financial and administrative resources allocated to reporting obligations. And the preparing a report, you see, needs dedicated staff with the technical know-how to lead the process. However, the process is led from the Attorney General's office, and the staff there, the attorneys who work on these reporting, have other duties to perform. They go to court and they have other schedules, so they cannot actually do this on a full-time basis. And so that also sets us back a bit. And but now we have a national mechanism for reporting and follow-ups, which prepares reports in consultation with other stakeholders across the country, and that requires financial, heavy financial outlay, because having meetings needs finances and all that. We are trying to surmount all these problems, and the frequency of reporting has not helped, because if we have to report every 2 years and we need all this financial outlay to do the reporting, it can be a problem. There is also a limited technical expertise. The attorneys at the National Mechanism for Reporting and Follow-ups in the Attorney General's office, who coordinate the reporting activities, are sort of jacks of all trades. We are supposed to know everything. They are expected to be experts in every subject, and that can be a challenge. So, in the first place, there can also be some staff turnover. After the people have been trained, they leave, and then you have to train again. So these sorts of issues are very problematic in our office for reporting in general, not only these two articles, but they make the matter worse. And then we also have reporting fatigue. We have so many reports to put together that sometimes it gets overwhelming, and then some of them get left behind, especially those that we don't have enough information on, like those that we need for Articles 21 and 24. However, it's not all doom and gloom. There is progress. As I've already mentioned, we've set up a national mechanism for reporting and follow-up in the Attorney General's office. It actually came out of a recommendation from a review, from our UPR review with the National Human Rights, from the Human Rights Council. And having set it up, it was set up at the highest level, by cabinet decision. And it's made up of all the ministries and agencies that actually have a bearing on human rights. We try to meet as often as possible, but it ends up being when we are going to prepare our national reports for the UPR. Now we are going to make sure that we use that same mechanism to prepare the regional report, and we have started. And I am very sure that once we get involved in doing the regional report, we are going to use all the information that we have for the UPR and more to do the reporting on the charter. And we are going to have to, this time around, address Article 21 and 24. So there is progress coming along the way. And we have recently added to the membership of the National Mechanism for Reporting and Follow-ups, the Ghana Statistical Service, which is responsible with other agencies for preparing Ghana's voluntary national review reports to the high-level political forum on sustainable development. Now, this process could also assist in reporting on Article 21 and 24, as they have some data in those reports which can be used for the reporting. So now we have them on board, and we have added the Ministry of Environment as well on board. We are going to be able to put together enough data to report on these two articles. As I've already said, our capacity needs are many. We need technical support to strengthen the NMRF, and we need funding for the NMRF, and we are lobbying our governments to put together that funding for us. But we would also appreciate it coming from other supporters, development partners. Now, the areas of collaboration that we can have with other stakeholders would be the area of data collection. And so we would like to collaborate with the Ghana Statistical Service and the Environmental Protection Agency in Ghana. And for capacity building, we would call on the AU and the UNHCR to see what they can do for us. Then we have knowledge sharing with other states in the region. We just came back from a workshop in Tanzania where we met other like-minded states in the region, and we shared a lot of knowledge. And we currently are trying to put together a group to facilitate this kind of knowledge sharing so that we can learn from each other. In fact, Kenya is doing some good things, and we will learn from them. We also would involve the affected communities in this reporting process, because they are the ones that are affected, and I'm sure their voice needs to be heard. So that's one thing we're going to do. And then we would like to engage government at the highest level, that is at the presidency, to make sure that in all our reporting, the government is aware of what is going on. We will report the situation, and having gotten the political will, we are sure that whatever challenges are there with the reporting, and whatever challenges are in the extractive sector will be better addressed when it's addressed from the highest level. Since I've not been given that much time, I will not go on and on again. I will just end here. Thank you very much for your attention. Sorry, I can't hear anything anymore. Is it possible for?
Can you hear now?
Yes, I can now. Thank you.
Okay, sorry about that. Yeah, we thank you for your very insightful presentation, which touched on quite a number of issues, some of which had already been alluded to by our colleagues from the National Human Rights Institutions. But you also raise other fundamental issues, which I think this really is the space for us to engage with some of those issues. Just like many other states, Ghana has not been reporting. I think you mentioned to us that the last report you submitted, the second report was in the year 1993 to 2001 or thereabout. So meaning all the years from 2001 or 2002 to date have not been reported on. So that period where you did not report, we would really be keen to understand what was happening. Is there probably an indication, or would that be an indication that there have not been any violations or things to report on? So those are things that we would want to ponder on even as we continue with this discussion. But I think the hope that we have is that you have told us that you are now in the process of preparing a combined report that would capture all the issues from the time that you stopped reporting to date. So we would be keen to maybe see that report so that then we can engage from the other side, the National Human Rights Institution and the civil state actors, the civil society actors, to also give their own comparative report or the shadow report to the Commission. Of course, the resource constraints are cross-cutting, but I think the issue that I pick there is the fact that the people who are involved in reporting at the Attorney General's office are probably the same report that report on any other reporting obligations, be it with the African Commission, the Human Rights Council, and any other treaty body that there is to report on, including, for instance, the Maputo Protocol and any other instruments that need to be reported on. So definitely that speaks to a huge gap that needs to be addressed both by the state and any partners in the room who can be able to pick that up and ensure that we streamline things at that level. The issue of high turnover within those institutions, I think cuts across. Within the national human rights institutions, I think they more or less face a similar challenge. People are trained, but after a while, they exit the institutions and new people come on board, and they have to begin the process of training them and building their capacity to be able to report on these obligations. So it's quite an issue that, of course, would require new strategies to address and ensure that we do not lag behind in terms of our reporting obligations. But we have hope because, as you said, we have things that sort of come across as good practices, including the cooperation that you have established with the national statistical offices, because they are basically the custodians of national data. So what kind of cooperation can we institute between national human rights institutions and the national statistical offices so that whatever data is generated by these institutions can become part and parcel of the data that we used for our national reporting at the end of the day. But you also mentioned one very critical and fundamental issue, that of involvement and participation of the affected communities, so that then their voice can be heard in this process. And for me, I think that was really quite instructive and a useful way of ensuring that we leave no one behind, even as we prepare our national reports, because the affected communities certainly have issues that they would want to raise in this process, and they need to be captured as part of the process. Yeah, so among many other issues that you have raised with us, and we thank you for those insights, we will give an opportunity to the audience later on to ask questions or interact with your presentation, but we really thank you for your submission. And at this juncture, ladies and gentlemen, allow me to bring someone from the civil society side. Yeah, we have heard from the NHRIs. The NHRI is semi-state, not state. Yeah, so they straddle between the state and the civil society. They are in between there. Not entirely state, but the also bear that character of the state. So we would now want to hear the perspectives from the civil society side before we open the floor to hear from the audience what their experiences have been also, and if they have any particular questions that they need the panelists to address. So over to you, Mr. Obet, from the civil society side. What are some of the best practices emanating from your end, and what are the challenges that you've been grappling with? What lessons are there to be learned so far in reporting on Article 21 and 24 of the African Charter on Human Rights? In the next few minutes, you have the floor.
Thank you so much, moderator, for giving me the floor. And thanks to you all for joining us. I think this is a very important conversation we are having at a time when the world is grappling with climate change, and at a time when the world, particularly the global north, is racing to secure critical minerals. I think in the past couple of years now, we have seen a lot of interest from the EU, from the US, interested in securing critical minerals that this continent was. And I think this brings us to the conversation of at what cost are we extracting minerals on the continent? We know that the continent mostly export its raw materials, natural resources, not necessarily value added on the continent. So I think within that context, appreciating the cost is important, and there's also a role that the state plays, as we have heard from the previous speakers, that they have an important role to report on Articles 21 and 24 of the African Charter. And these two articles relate to ensuring that African citizens are living in an environment that is safe, that is clean, that is not harmful to their well-being, and also to the right to disposing wealth, which is the natural resources that the continent has. So within that background, I think the African Commission on Human and People's Rights is fully aware of the challenges that the continent is confronted with. And I wanted to share a little bit in terms of background, why the African Commission created a special working group on human rights, extractives, and environment. So in 2009, there were reports that were before the commission, which resulted in the commission creating that special working group, which is currently chaired by Commissioner Solomon Deso. He's been championing state reporting under Articles 21 and 29 of 24 of the African Charter on Human and People's Rights. And over the years, one of the things that has been noted is also my previous panelists have alluded that states have not been reporting. Ghana is already confirmed that their last report was far as back as 1990s. But for states that have been reporting, one of the challenges is inconsistencies in approach in terms of the provision relevant and providing adequate information. Then I think overall on the continent, one of the challenges noted by the working group is that there is no comprehensive and systematic approach on how they should be reporting. So with that background, the working group developed some special reporting guidelines on those two articles. So if you go onto the website of the African Commission on Human and People's Rights, you see the reporting guidelines that are specific to these two articles and what information is required from states when they report under the two articles. So in relation to Article 21, for instance, states are expected to report the type of natural resources that are being exploited or that are available within their territory, the activities that are being undertaken as well by extractive industry within their territory, and the list of transnational or multinational companies and their subsidiaries, as well as local enterprises that are involved in extraction. Then information on the size, the lifestyle of populations that live in these mining communities, And quite important, the legal framework, states are expected to report the level at which their legal framework provide guarantees on ownership over land and natural resources to people. Then information on local participation and also human rights compliance by both large scale and small scale extractives. So largely this is the information.
Coming so quickly.
Yes, I think they skipped a few speakers.
That's why.
I think the online speakers are agreeing with me. But anyway, so yeah, on a lighter note, so what role can civil society actors play to support states in meeting their obligations to report? So I think we have already heard from the previous speakers. My colleague Christine mentioned the issue of alternative reporting. So the African Commission allows organizations that have observer status to produce and present reports during its sessions. So this is more of independent assessments that civil society organizations can do. So we can do our own monitoring on the ground of what kind of investments in terms of natural resource investments by multinational or even local investors that are coming into our space, and complement the efforts by government by producing those alternative reporting. I think in the past, Zella has also been active in this space. Center for Human Rights and many other organizations have been reporting to the African Commission, but on different articles, but particularly Articles 21 and 24, that is the major challenges, as we have heard before. And one of the other critical important role that civil society can play is monitoring and documentation by collecting evidence of human rights violations or environmental violations in the extractive sector. I think civil society at a better space to interact with communities that live with mining companies, to track, to monitor, to document, and use those as evidence to support the state during reporting processes, but also to report independently as part of the alternative report that I mentioned earlier on. Previously, I mentioned that legal frameworks that states have put in place are also supposed to be part of the reports that states report to the Commission. So civil society have a role to review our current national legislation on environment, human rights, and extractives. To what extent do our natural resources laws provide for sufficient protection as guaranteed by Articles 21 and 24? So this is a role that civil society has to play, doing the analysis of the laws, but also doing advocacy at national level to ensure that those gaps are addressed by, law reform. And I think we are in a space where the national human rights institutions have been championing the cause across the continent, even though there are, challenges within states, but most African countries already have national human rights institutions who have the role, and we can complement them by, giving them information and capacity to build them. Obviously, Dr. Adusu highlighted to the issue of funding being a key gap. So civil society has, fundraised to support government efforts so that we are able to also report, in as much as we would want to hold corporations and government to account. We also have a role to complement and support them. So I think fundraising with development partners would go a long way in assisting the reporting that is expected by the African Commission. So I want to end here and thank you.
Thank you very much, Obert, for those useful insights from the civil society side. And we can not agree with you more that I think some of the challenges that you have raised cut across, and therefore there's need for all responsible actors to act in concert to be able to overcome some of these challenges and make this process more effective and impactful. And civil society definitely has a significant role to play where we have talked about challenges in terms of raising enough resources to be able to ensure that the process runs smoothly. I think you have clearly alluded to the fact that you can step in and support fundraising efforts and resource mobilization efforts to bridge those gaps. You have also alluded to the fact that civil society also can acquire observer status at the African Commission, and therefore, on their own accord, submit an alternative or shadow report. That's an opportunity that the actors in the room can be able to take advantage of. So if the state delays, civil society, you also have that space. You can seize that space and to submit your own alternative or shadow report. But I think it would make more sense because if the state reports, then your report can also complement what the report from the state has talked about or mentioned. But you also talked about advocacy, either to reform laws that appear to be repugnant, or also advocacy to institute probably better laws that would address the issues or challenges affected by communities, especially in mining or extractive areas. That, among many other issues that you raised, I think we thank you for that submission. And in the next few minutes, I think we will now open up the floor so that we take a round of questions or comments from the people in the room. And I'm quite aware that we could also be having some people online. If there's anyone from the online space who also has a question or a comment, we will also be generous enough to allow you to also participate with us in the next few minutes. So I'll take a couple of questions. In the interest of time, I think I'll give 3 first, and then if we have more time, we will be able to open the floor for another round of questions. So we have 1, 2, then 3. Let's begin with those. Oh, okay, 4 first. We'll take the hand at the back. So 1, 2, 3, 4 at the back. And then if we have more time, we will open the floor again for another round of questions. Thank you.
Thank you.
Thank you very much for these most valuable insights on the local and regional context. My name is Eckhard von Malsen. I am a German business and human rights lawyer and consultant, and I actually work for the extractive industry. My clients are from the United States, from Europe, and they are concerned about or looking at 3 things. First of all is the local and regional context, so the Maputo Protocol, the Charter, all these very useful instruments. Secondly, of course, they look at the European legislative framework. You have heard of the Critical Raw Materials Act of this year, conflict minerals regulation in place since a couple of years, and in the future, the Corporate Sustainable Due Diligence Directive, which they have to abide to. And the third thing they are concerned is, as a business, of course, their competitors who, let's say it softly, often do not really are concerned about these standards and or have other standards, and they are a competitive risk for them. How do you see on the ground the impact of, for example, European legislation with the actors? Is that already grasping? Is this a reality already? Or is that some faraway legislative theory for you that you have heard about? Thank you.
Thank you very much. My name is Lloyd Kuvea from the Center for Human Rights at the University of Pretoria. We have worked with several states in the past few years, and we will continue to do so on state reporting under the Maputo Protocol. And we want to move on now to state reporting again, looking at issues of business and human rights, the extractive sector, as well as the Kampala Convention. I just wanted to find out from the presenters, in terms of building trust between civil society and the state, because sometimes states submit their state reports to the mechanisms without necessarily perhaps sharing with civil society organizations so that they are able to also prepare an alternative or shadow report. How can trust be built so that this happens? Thank you so much.
Thank you.
Thank you very much. My name is Masood and I come from Ethiopia. I work for the consortium of Ethiopian human rights organizations. Thank you, panelists. So considering that this extractive industry is also very sensitive and very political because it involves a lot of money that ordinary people don't know what's happening underground or so. So this the issue of trust between the national human rights institutions, the state institutions and civil societies is always complicated. So for instance, from the experience of Ghana, what has been, I see a lot of challenge and it seems like even the Ghana government doesn't have the appetite to report while the government has signed and is part of the charter. So if we see this much reluctance from state institutions who are state parties, then I wish we heard from the African Commission on what are the compliance requirements, what are the remedies then if states fail to report or if they are not reporting for so long. So this is one important issue. The other issue is also working with civil societies. We know there is a resource issue and we understand that, but complementing between the civil society, the national human rights institutions and the state institutions is also very important. It has also at some point the issue of if you are closely working with the state institutions, you happen to be seen as supporting status. And you would have the chance of being seen as supporting status and pro-government. So how you understand these situations in terms of working with civil societies and what specifically, especially from the Kenya National Human Rights Institutions, what you technical support provide for local human rights institutions to engage in this because you can't do all the job. Thank you.
Thank you. The last one at the back, and I kindly ask you to be very precise in your question so that then we save on time. Kindly just go to the question straight away so that we allow more time for others.
Thank you very much. My name is Caesar Katebe from Zambia Alliance of Women. When you look at the two articles that have been referred to, in reference to state reporting, you realize that, for example, civil society organizations like ourselves are really pushing the agenda of beneficiation in terms of mineral extraction in our country. Yet we have this opportunity where we report these aspects to the African Commission, but there's very little traction in terms of seeing this aspect of beneficiations. Yet it's also espoused in the Africa Mining Vision. What more can we do to ensure that the aspect of beneficiation is actualized?
Thank you very much. So I think we'll do with those first, and I'll give an opportunity to all the panelists, including Dr. Sylvia online, to give their take on those questions that have been raised from the floor. You can choose any questions that you want to respond to, but if there's one that may not have been addressed, then I'll come back and maybe raise it so that we don't lose on any of the questions. We could start with you, Christina.
Okay, sorry. Thank you for the great questions. With regards to the local and regional context and the EU and the frameworks that are coming up, I know as a country, Kenya, we have the National Action Plan, and now we're developing tools that can help guide businesses on compliance with human rights. And we're working on the human rights due diligence tool that we hope will mirror some of these laws and policies that are in the global arena. And why we're also doing this is because we're looking at a whole value chain. So we're encouraging all those in the value chain, even in the local context, to comply so that, we're also not losing out on business. And given it's also a political, there's a political aspect that comes in because of the interests that are in the extractives sector. So we're trying to help the state also see the sense in having businesses and all stakeholders comply for the effective or sustainable use of the resources. With regards to building trust between the CSOs and the states, I think that's where we come in heavily as a national human rights institution. We have platforms where we engage both the state and the civil society organizations, especially when we're working on reports. I know the state also tries to coordinate stakeholders, but as an NHRI, we bring them together just to tease out or iron out some of the issues or violations that, of course, we may not immediately be aware of. Technical support, again, we guide the civil society organizations on how best to package some of this information before they present it to regional and international reporting mechanisms. I think in a nutshell, those would be my initial thoughts. Thank you.
Thank you. Obed?
Thank you so much for the questions. So I'll try to address the question on European legislation impact on the continent. So I want to agree with my colleague Christine on what Kenya has already been doing. I think previously we had that, I think in the plenary session that they were developing human rights due diligence framework. I think in a way that is also drawing lessons from the EU frameworks, like the Corporate Sustainability Due Diligence Directive. So I think that is impact on the ground, seeing that Kenya is already doing something and taking lessons from Europe. But beyond Kenya, I think other countries are also doing the same to come up with either mandatory reporting, sustainability reports in the form of ESG reports. So I'll give an example for Zimbabwe. I think in 2021, the government of Zimbabwe released listing requirements for companies listed on the Zimbabwe Stock Exchange or Victoria Falls to report on sustainability. So all companies, including international, multinational companies, as long as they are listed in Zimbabwe, they are now expected to also produce sustainability reports. So that is also drawing also from the EU corporate reporting sustainability directives. For procurement, we have also heard that the government now wants to procure services from companies that are compliant with sustainability report. So in a way, I think we are seeing some influence, although it might not be very direct, but there's some influence that we are seeing from our national legislation drawing from Europe. Then I also tried to address Lloyd's question, how do we build trust? CSOs and government. I think, yeah, it's quite a difficult one, because of the context that we live in, particularly because when governments go to report, they also do not want CSOs to see, what is contained in their reports. And conversely, CSOs do the same, produce their shadow reports, and government is surprised when it goes there. Like, so you guys are reporting differently. What have you been doing? So I think one of the things we could do is regular dialogue between CSOs and government. This could even be formal or informal channels, and also maybe doing some joint monitoring visits in some of the hotspot areas where human rights are happening. Violations, and as far as also mining is related. So having joint projects, regular meetings, I think that can also improve in building trust. As for the question on Ghana not reporting, I think I'll leave that to Sylvia. I think she might be better placed to share the experience. Thanks.
Thank you. That, in addition to the question on beneficiation, I think that's the only one that has not been tackled so far. So, Dr. Sylvia, you have the floor, but also if in your own words, you could address the question on beneficiation as had been raised earlier.
Okay, thank you. I will only address the question of the one on Ghana, please. If somebody else can take the beneficiation one, please. Okay, so with Ghana, I wouldn't say that there's no appetite to report. I would just say that it was not one of the priorities. because we've been reporting on so many, I mentioned reporting fatigue. We've been reporting on to so many bodies that some of these ones get pushed to the background, especially since most of what we've been reporting on is quite repetitive, in the sense that we do report on the extractive industry elsewhere, but maybe it's just that we've not done it under this one, under the charter. So right now, looking at how the growing awareness on environmental issues and states being forced to become accountable and all that, it is something that has come back on the front burner. So we are actually in the process of working on our report as we speak. So definitely it is something that we will come to. It is not a deliberate thing that Ghana is not reporting. With our few challenges that I have mentioned, which we are overcoming, I'm sure we are going to get there. Now, with engagement of civil society, and in Ghana, we don't have any suspicions, not that we don't have any, but we don't have any high level of suspicion between the CSOs and the state in these reporting issues, because we do engage them very much in our reporting. We engage with the POS Foundation in Ghana, which is a coalition of all the CSOs. And once we contact POS Foundation, they bring along all the CSOs that are involved in the human rights field, and we validate our report with them. We always have a validation meeting where all of them are there online. They give us their inputs, and by the time we leave the room, we have their inputs in our report. We even went with them to Geneva when we had the Human Rights Council, and it has always been a cordial relationship for Ghana. I have not seen any mistrust between us as at now. So looking at even the reporting on the Article 21 and 24, we are going to engage them heavily again. As I said, there are several environmental NGOs in the mining sector and in the extractive sector. We are going to engage them, and even the communities. So, and we even have our National Human Rights Institution serving on the national mechanism that does the reporting. So we are always looking at other stakeholders, and there's not that level of mistrust that maybe exists somewhere else. That's what I'll say about the CSOs. And yeah, I think that's what I would say about the 2 points that was raised by the delegate from Ethiopia. Thank you.
Thank you very much, Dr. Sylvia. So I don't know, is anyone here willing to take on the question on beneficiation just before we bring this session to a close?
I did not get the question. Was it beneficiation or benefit sharing?
I think it was on beneficiation.
Beneficiation.
Yes, not benefit sharing.
All right. I think, yeah, like I alluded to in my opening remarks, the question of value addition of minerals, that I think as a continent that has been a challenge. I think for me, it goes to what governments ultimately, because in almost all African countries, governments, these minerals, they vest in the state. So the state has so much control that it can decide if it wants minerals to be value added before they are exported. And I think we have seen interest, I think in DRC, they are trying to set up some battery manufacturing plant with support from UNECA. And this is also being supported by European financial institutions. But this is coming from that background that we have not been, value adding the minerals and exporting, raw materials mostly. So I would say states need to do more, because they do have so much control in terms of what they can do with the minerals that they have. But I think there's no political will. But the second thing is also a lot of governments are desperate to attract investments. And the race to the bottom. No one wants to be, the country that is so much difficult to operate in. So in a way, governments start giving incentives that allow companies to extract and export, raw materials. So that's one of the challenges that we are confronted with. But I'm happy to, take the conversation forward, and we can see how we can maybe come up with some framework or also learn from some countries. I know, for instance, in Indonesia, they've actually, made it mandatory for the export of nickel. Zimbabwe also did the same with lithium, but we all question like, what level of value addition is expected if you are only crushing minerals from rocks into brine, for instance, if it's pegmatite or lepidolite for lithium. So when you crush it, you have not really value added. We have only just, produced concentrate, which is not an end product of anything, really. Thanks.
Thank you very much. I think I saw a hand there. That could be the last one. So I'll give you 1 minute.
Thank you. I thank for this presentation. It is not a question, but a comment. Concern capacities building in Africa. The challenge concern how to help actors in to appropriate engineering and to appropriate the concepts to my English I try, huh? Donc to appropriate the concept, the accommodation in accounting of taxonomy, because if you take all actors, government, Commission National of Human Rights, or civil society, or enterprise or extractive industry sector, there are we need to help them to maîtrise, hein? Master, okay, I can use French? Oui. Voilà, thank you. Donc, j'étais en train de dire que les défis à ce niveau.
I was saying that's the challenge at this level.
Voilà. Donc, le défi à ce niveau, c'est que il faut accompagner les différents acteurs dans la maîtrise de la taxonomie. Parce que quand vous prenez les contributions déterminées.
Wait for translation. The challenge at that level is someone should master the flow of this channel.
Voilà. Quand vous prenez au titre des contributions déterminées, selon l'accord de Paris depuis 2015.
When you use the Paris Agreement of 2015.
Donc, il y a les CDN conditionnels et les CDN inconditionnels. Au titre des CDN inconditionnels, ou vraiment au-delà des CDN conditionnels où l'État s'est déjà engagé, au niveau des CDN inconditionnels, les entreprises, tous les différents acteurs ont leur mot à dire.
CDM.
Oui. Est-ce que vous avez une question spécifique?
Non, c'est juste une contribution pour dire que nous, on attend de la société civile, et de tous les acteurs un renforcement des capacités, donc au niveau de la maîtrise, hein, donc de la taxonomie, des outils. Merci.
I have a concern.
Merci.
Can I go on?
We will have to end there in the interest of time because our time is really, really fast spent. We are already past the hour. So I indulge you, please, kindly, if you have any additional questions or comments, the panelists will still be with you here so that you can continue the conversation. So as we conclude, in 1 second each, for each of the panelists, you are concluding remark based on the conversation that we've had. 1 second each. I'll begin with you, Obet. One second. Your closing remark.
I think for me, I would call upon civil society actors to complement government efforts by producing reports that can also be tabled before the commission. As we have heard from Ghana and also from even Kenya that there hasn't been information coming through. So that means there's a gap and there's a lot of work that we need to do to document. Thank you.
Thank you.
Thank you. For me, I think it would just be to use the available laws and policies that we already have. They're good. It's just a matter of implementing and reporting appropriately. Thanks.
Dr. Sylvia online. Dr. Sylvia in 1 second. Okay, probably she dropped off. Okay. Dr. Sylvia? Okay, she's not there. No problem. Yeah, so we have to bring this to an end, colleagues. But thank you so much for those very insightful and informative presentations. I thank the panelists for your contributions. Indeed, this would not have been possible without your interventions. You have all alluded to a number of things that we need to be aware of, including the issue of non-reporting or delayed reporting, which is something that we need to address. How can we ensure that the states and even the civil society actors begin now to take up that responsibility of reporting? There was the whole question of ineffective public participation. Even as we engage with the reporting process, we need to step up and ensure that the affected communities are also part and parcel of the reporting process. Then my colleague and friend from the National Human Rights Institution here in Kenya, you alluded to the issue of the non-recognition of the data that comes from the national human rights institutions and probably any other actors. How do we collaborate so that then the data that you generate out of your complaints handling mechanism or system can become part and parcel of what is contained and submitted in form of the reports that you submit? The whole question of weak enforcement and implementation of decisions or recommendations coming from or concluding observations coming from the mechanisms or the institutions is something that we need to address ourselves too, because without implementation or with weak implementation, then we do not get to enjoy the benefits that are intended out of those decisions or recommendations. Resource constraints, which can also be tied together with the issue that we have discussed at length of reporting fatigue. If we do not have enough staff to be able to take on this responsibility, then those who are there, they get weighed down, they get tired because they report to so many mechanisms. How can we harmonize all this so that we make the process more friendlier and easy to comply with? Then the frequency of reporting, I'm not so sure whether we had any proper response to that. The reporting frequency is after every 2 years. Is that adequate? Is it probably too soon? Or what do we need to do about it? In terms of the good practices that we have alluded to, the issue of engaging stakeholders at every moment so that they sail with us and ensure that their voices are heard. Then technical support to both civil society actors, but also state actors, because we imagine sometimes that they have the knowledge and know-how to do the reporting on this. But if they have weaknesses there, how do we step up and support them to do that? You alluded to the whole question of cooperation between the non-state actors, national statistical offices and national human rights institutions, or collaboration with Ministry of Environment or the agencies that are involved with environmental issues, so that then their knowledge and their expertise can be incorporated in the whole reporting process. And then finally, CSOs rising up and taking up the observer status at the African Commission so that they can also submit their reports, either activity reports or alternative reports, to weigh in on the issues that might have been missed out from the state reporting. I thank you very much for your attentive listening and your participation in this session, and I wish you all a pleasant afternoon. But a round of applause to our panelists and for yourselves for having patiently waited and contributed to the success of this session. I thank you very much. Okay, I am advised that you can come in front here so that we can take a group photo as part of our documentation for this session. If you can kindly come to the front here, we will do a group photo to conclude on our session. Thank you. Kindly come to the front here so that we can do a group photo. We will need to release this room to the next session. So kindly quickly come to the front for a group photo.